41 years later, client will finally adjust status on the 245I. We have another one, right? Another I-140 approved petition. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Also, if you want, please join us on our private Facebook group where we answer questions live at least twice a month. Let's get right into it. We're going to do a case study. I'll give you timelines and I will give you the requirements, right? What we actually did to get this approval, okay? So this is really good, and it is really good for someone who has been living here for 41 years, okay? 4 decades. After filing multiple petitions without success, after changing lawyers after lawyers without success, but we're finally able to get her, okay, an approval, and we're going to get her a green card, okay? Let's get right into it. Let's start with timeline. We filed for I-140 under National Interest Waiver petition on September 9, and we just got the approval on August 31st, 2022. A full year, almost, like only missing 10 days, but it's almost 12 months, right? 11 months and 20 days later, we got the approval. That's pretty much the timeline. So now we have to move and adjust status. The question becomes, are you eligible to adjust status? But prior to going to the second question, we are going to answer the first question. Can I self-petition? Yes, you can self-petition, provided that you meet the national interest waiver requirements under EB2 category, employment-based type of green card. So what are the requirements? Number one, you must have a higher education. So they're talking about master degree. If you don't have a master degree, you can have a bachelor degree plus 5 years of experience. It doesn't matter if the bachelor degree is from overseas, as long as there's an equivalence, right? And then you have the 5-year solid experience. Then you meet the higher education requirement. That was the case for our client. She had a bachelor degree from overseas, and she had at least, fair enough, more than 5 years of experience. You don't have to have more, but 5 years is the minimum, right? And on top of that, she is a certified public accountant, okay? And she is an entrepreneur. Remember, we've been talking about entrepreneurship as a way to ask for national interest waiver, but you don't really have to be an entrepreneur. You can be well positioned in your field too, because remember, you have to have the skills, extraordinary skills or special skills above the average person, either in science, business, technology, media, and so forth, and arts, you know. So the second requirement is that the endeavor in question, whatever you're doing, has to have merit, substantial merit, and national importance. In her case, she's a business owner. What she does is that she is in the real estate business. She buys houses and sells them. And when she sells them to specific type of people, low-income people. And sometimes she rents them out to low-income people as well, people who usually not get a traditional loan at the bank because of the income. Then they'll come to her, and she works as a middleman and help with the arrangement so she can sell those type of people. So that was like a very specific way of doing her business, and we had to show that with a lot of evidence. Okay, we had the evidence. We had basically when it comes to talking about national importance, that's when we had to show that she was able to hire people. She hired independent contractors when it comes to remodeling those houses. She hired a lot of people when it comes to doing those transactions, and then property manager, especially when it comes to renting out those houses. Okay, we had to show that as well. And then the third thing is that you have to be well positioned to advance that endeavor. And then she's well positioned because she has the skills, the experience. That requirement was met easily. And then lastly, you have to show that it is in the best interest of this government to waive the job requirement and labor certification requirement. So that's what we're able to show by the fact that she is able to hire people, pretty much creating jobs, even though those jobs were seasonal, right? She was able to hire people and therefore helping the economy of this country. So we're able to prove it through entrepreneurship. But let me point out this to you. You don't have to have business in order to qualify for EB2 type of visa. You just have to have something that you're doing, that you have special skills in the field that you're doing, and that whatever that you're doing as a job has substantial importance, okay? And merit, substantial merit, national importance, those two things. And really convince this USCIS, which is the government, that it's better for them to give you the green card on your own. Okay, so if you need a consultation, please call 202-751-2180 or email me bijoux.ngwandaesq@gmail.com or click the link below. Consultation fees apply as usual. You can schedule your own consultation on your own time. So now the second question, we're going to the second question. Second question is now, can I adjust status? Well, you have to ask yourself that, because we're not going to take your case if we know that you're not going to be able to adjust status, right? In order to adjust status, you have to be found admissible. So pretty much you have to meet statutory requirement for adjustment of status. And in her case, we're going to do it under 245I because she doesn't qualify under 245A because of unlawful presence. What does 245I entails? Basically, 245I forgives unlawful presence, work without authorization, and entry without inspection in her case. And then it simply says that if you have an old petition that was filed on April 30th, 2001, at the time it was filed, the petition was either approved or approvable. You can use it really pretty much with this new petition in order to adjust status. We have talked about 245 before. Sorry, I'm not going to go over it again, but we are going to adjust status under 245I, which is a great news. Perhaps this is the best we've done this year so far. The year is still there, right? We don't know what else we'll get as surprise, but perhaps this is the best we've done. This was challenging to come up with this argument for I-140, but we did. We pull it together. Sometimes it's about the way you present it. So you need to have a qualifying attorney, experience in those type of petitions to put an argument for you before USCIS. And you have to know that if you cannot adjust status under 245I, you can adjust under 245A, and you can even go through consular processing. But how do you know? Assess your case. Okay, that's why consultation is available, so that you can really assess your case and know if this is the best option for you. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. Until next time, bye-bye.